would like to speak to you about the matching process between surrogates and intended parents. It's actually through my work as an attorney drafting and reviewing agreements that I have found issues that I think are best resolved before the actual process of contracting and negotiating the agreement during the matching process. And I have found all too often that the intended parents and the surrogate have begun the process of drafting the agreement and negotiating terms, and there may be some important issues that were not fully vetted when the intended parents and the surrogate was deciding, wow, this seems like a good match and we want to go forward. I think to the extent that you can avoid misunderstandings during the legal process of drafting and negotiating the agreement, or coming to the realization that there are some fairly important or very important issues that you don't agree on, it becomes difficult to sometimes get beyond the agreement, or one or both parties in moving forward, even if the agreement has been negotiated and executed. One or both parties may feel not great about the situation, and when it comes to surrogacy, you really want to avoid that scenario. So some of the issues where I have most often found sort of a lack of understanding is in the area of compensation, where usually the parties, understand what the surrogate is asking for with respect to her base compensation. That's usually not an area of misunderstanding. But there are a lot of other fees, reimbursements, and add-ons that may not have been discussed, and which end up being very important to one party or the other. For example, some of these issues could be housekeeping, child care, lost wages. Is there going to be a cap on the lost wages? Often we see an incidental, non-accountable monthly expense fee. What is that going to be, and what's included in non-accountable expenses? In other words, there are no receipts required. So while I don't think the intended parents and the surrogates have to come to the table at the time of entering into the legal agreement completely having discussed in major detail every one of these issues, I think that each party has to decide what is really important there and make sure that the other side, whether that the other side's the intended parent or the surrogate, is fairly close in agreement, so that in general you have a good understanding and a common way of looking at how you want to proceed with compensation. Another area that I find may not have been fully discussed or considered is in the area of termination of the pregnancy. Often I will find a surrogate who will indicate that under no circumstances do they agree with termination of a pregnancy, including selective termination if there are multiple fetuses, except in the one instance where the surrogate's life is threatened. And many times I will discuss this issue with the intended parents, and they will say, well, we agree with that. We don't agree with selective termination, and we don't want to consider abortion. We don't agree with it. When I delve into that area a little more deeply, and I feel it's important to delve into that area, to really have an understanding. And I will ask a question, well, what if you found out that the child was missing one or more limbs? No, we wouldn't agree with a termination. What if the child, the fetus, was discovered to have Down syndrome? No, that's not a problem. What if there was a condition that was so severe that the fetus was not expected to survive, or if it did survive delivery, it would be expected to live only a short time, maybe a few weeks or a few months, and during that time be subjected to a great deal of pain, medical processes that would be very painful, and the child would really not expect to have any sort of quality of life but be in pain and distress. And intended parents may say, oh, well, that's a different scenario. And in that situation, yes, we would want to have the option of abortion. And it may be in that scenario that the surrogate, nevertheless, even in that situation, would not want to terminate. So while these are issues that one may not really want to think about or expect, these are issues that are important to the contract. Figuring out as many areas where something could happen and ensuring that there is the best possible understanding by both parties and an agreement. That's the way you want to go forward. In some instances, I have found that intended parents and surrogates working through an agency are expected to be dealing more independently with certain issues such as insurance. And I find that when it comes to the drafting stage, there may be problems with the insurance issues and misunderstandings and cost issues that the intended parents didn't anticipate. So what I also think is very important is that if you are working through either an agency who is doing the matching process or an attorney who's doing the matching process, you have a complete understanding of what that attorney or agency is looking at and considering during the matching process. Beyond issues of termination and compensation, there are also important issues that I don't always feel are well vetted in the area of how much involvement the intended parent or parents want during the pregnancy. And you may have a situation where the intended parents want a lot of involvement, perhaps participation and attendance at all the medicals, weekly personal visits or telephone conversations. And nothing is wrong or right here, but the issue is whether both the intended parents and the surrogate are in agreement on what that should be. And you don't want to find during the process that one or the other has felt like boundaries have been crossed or boundaries are not respected, and then you start to have breakdowns in the relationship. So I think that the more you explore the various issues during the matching process, whether that's the intended parents and the surrogate if they're doing this independently, or whether it's ensuring that the agency or the attorney who's doing the matching is exploring these issues with each party, the better off it's going to be during the contract negotiations and, most importantly, during the pregnancy. This way you can have the best chance of having a wonderful journey, and both the intended parents and the surrogate walking away from the situation feeling really good, really positive, and really happy about the whole surrogacy journey. I hope you find this helpful, and I wish you all the very best. Thank you.